Please, Your Lordship.
Yes.
My lord, I beg to mention item number 7, my lord. We have filed a one IA, my lord. Yesterday, your lordship was pleased to direct to be listed along with the IA,
Hmm.
but it has not been listed.
Hmm.
So I may be permitted to requisition that, my lord.
Is it numbered or not?
Serial number, though, we got it, my lord. We filed on Saturday.
No, you filed it Saturday, but the IA is numbered or not?
IA, my lord, if it is,
Unless it is numbered, how can we requisition
yes,
it?
it is numbered. Going to be numbered now also. Only we'll just make an effort, my lord, if it comes all right.
Okay, otherwise we can take up tomorrow.
Tomorrow.
Oh,
Or can it be tomorrow? Or tomorrow, though, we have 18 matters. We'll make a try, my lord.
what is it?
Tomorrow I got several matters. Number,
Okay.
18 numbers of cases.
Okay, let us see. If not, then
Yes,
we
if
will
doesn't come, then your lordship takes it up.
have it on Thursday.
Wait, PJ Lord. I also pray for listing of an IA for Friday, Lord, but not numbered, Lord. That's the difficulty. I is for early hearing of a contempt application, Lord, pending before your Lordship, but not numbered. I is not numbered.
Okay.
On Friday, your Lordship. Oblige, your Lordship.
I beg to mention the PIL, your lordship.
Oh.
It was last is listed on 27th of March.
Oh,
And your lordship had directed to list the matter after 10 days.
oh,
Now, more than 60 days have elapsed, your lordship, and the matter is yet to be listed.
okay, 16 June.
16 June.
Yeah.
Oblige.
Item 1 for orders.
May I please, Your Lordship?
Yes.
My lord, this interlocutory application for condonation of delay, my lord.
Oh.
There is 13 days delay in preparing this writ appeal, my lord.
Who are the respondents?
My lord,
Who are the respondents?
respondent, my lord, 6 and 7 are private respondent, my lord. And the rest are, my lord, state respondent and Department of
notice has to go,
Education and my lord, Deputy Commissioner.
Yeah. The notice has to be.
My
But Mr.
DK Duff.
DK Das, legal counsel for the petitioner. In the IO, huh? For the applicant. Issue notice. So, Mr.
He's here for 3 minutes.
Education,
I'm preparing for
MS,
BTEC.
Decal,
Correspondence for 1, 2, 4, and 5.
and standing council, elementary education. Appears for 1,
2, 4, and 5.
2, 4, and 5. And Mr. So let us govern the appears for the respondent number 3. What was his name? What was his name?
3 minutes.
Yeah, okay. Applicant to take steps for service of notice on the respondent 6 and 7 by a registered proceeding. List after 4 weeks.
Item 2.
Oh, no.
May I please, Your Lordship, there's a delay of 4 days, my lord. in
I
filing.
know. But then the opposite party,
Only one respondent, sole respondent.
then notice will have to go.
One.
But Mr.
AK Sahib.
Yes, I will let it counsel for that. Issue notice. Looking to take steps for service of notice on the cell respondent. By registered proceeding within 1 week, stuff to 4 weeks.
Grateful.
3.
May I please, Your Lordship? My lord, we have filed 2 IAs, my lord. One IA for seeking leave, my lord, because we are not a media party respondent in the writ petition, my lord.
Hmm.
So we want to prefer the appeal, my lord. Appeal also preferred.
But
So
first you'll have to take,
steps upon only, my lord, respond number 6, my lord. 7.
which is the
already-
taking leave. IA
My lord.
1704.
Yes, my lord.
That has not been listed now. Listed. I said. My lord, this is also interconnected with supplementary item. They have filed 2 appeals, same subject.
Supplementary.
They are challenging two different single judges judgments on the same subject matter. So all are inextricably related. And they have also filed 3 miscellaneous petitions, man. And so far as the miscellaneous petition challenging one judgment, there is a delay of 1,300 days.
That is the instant one.
Naturally, I have a right to
Correct.
file an objection.
That will give you
And in the other
They
also,
valid only for the leave, man.
no,
leave to file an appeal.
Yes.
they have filed 2 appeals.
Mm.
One is
That
against
is
2
separate
single judge
matter.
judgments. So far as the first single judge judgment is concerned, there is a condemnation of delay. And there I want to file that there was an.
No, that continuation of delay,
Delay
will
for-
consider it only after this I is considered
In the other.
in this present case.
Ultimately, everything will be correlated. Everything will be correlated.
No, fine. But then here there's a IA.
Yeah.
Seeking leave to file an appeal.
Yes.
So we'll have to consider this first.
At the same time, your lordship will have to take up that.
That will come, my lord, item number
That-
7, my lord. That
that-
is two independent. Independent judgment.
All are related.
Okay, that will.
Not that I am deferring the matter.
Uh-huh.
I am just pointing it
Item
out.
number 7 we
Even
club
for
with
the
this one.
purpose
That
of
is
this-
altogether different.
For the
But
purpose of this interim order, your lordship will have to have a look at the item number 7 of the supplementary list. That is my submission.
that, my lord, item supply 7, my lord, will come.
Then this 7 will have to come up along with this.
Yes, my lord.
Yes, after some time, my lord, but
In
leave
fact,
has
it
to
has
be
come.
decided.
In fact,
Leave has to be decided.
That's why this has to
Yes,
be
yes.
decided. Notice has to go, so because there's a private.
Only one private respondent
Ah.
number.
We have
six
to, we
left.
have to hear the private respondent.
Yeah, my lord, 7 he is appearing private respondent.
You are appearing for the 7.
7 আপনি নহয়
In
নেকি?
this present
প্ৰতিমা
case,
বৰা নহয় নেকি?
Fatima Bora, yes,
Bonita.
we are here for 7. There is any other respondent?
হাতি কলেজ High court. নাই সেইটো
I am
no,
responding.
are you authorized to appear?
Yes, I have filed caveat.
No, in this IA?
No.
Okay. Caveat is there, caveat is there. Caveat is filed by whom? Who is the
filed
caveat?
by one
My junior.
Pranita Bora.
Who is the caveat?
7 or
No, item 3.
দুটাত কেবিন মানে
Pranita Bora. Pranita Bora. Huh, we have filed the caveat.
So, both these cases I am appearing for 7 mile, rest will be your loss. Supplementary case list and this.
How about 1 to 6?
Or government appears, man.
না গভর্নমেন্ট সব রিপেয়ার হবো আপ টু 4
Finance, Director Higher Education. And Hari College, 6.
6 notice has to
Notice has to go.
6 only my lord, rest government and my land.
But J.I. Barwaya and it also put applicants. Stop. Issue notice. Mr. A.R.W. Learned Standing Council, Higher Education.
Yeah, 5.
Oh, 2, 3, and 4, huh? Then 1, Mr. M.S. R.V. Bora, Learned Government. Appears for the respond number 1. And Mr. A.R.W. Higher Education for
And same in the other cases, man.
2, 3, and 5. Finance. Mr. H.
Just to
Alia,
say-
Learned Standing Council Finance appears for
Yes,
the
what
respond
is-
number 4.
And we are also for the other cases.
And Mr. A.C. Barbara, Learned
Supplementary.
Senior Council, assisted by
And they
N. Day,
also
appears for the respond number 7 by filing caveat. Stop. Applicant to take steps for service of notice and to respond number 6
I do anybody
by registered proceeding within 1 week,
within 3 days.
least after 4 weeks.
And now, my lord, the supplementary matter. There also we are appealing.
Let it come, my
the
lord, I
supplement
let
come up. Let it
let
come
come
up.
with
Let's
serially.
come to that.
No, let it come up.
Let it be called on.
Oh, it will be called up. I'm sorry.
Here you say hurt. Mr. Okay, take the caveat. আজি এটা আৰু বেলেগ কপি দিছে only after leave only will consider একেবাৰে ভালকে
My lord, there is a delay of 173 days. So.
Okay, heard, Mr.
Dean on this.
Just one thing I wanted to point out, I'm preparing for the APDC. Perhaps the IA may need to be corrected because it was filed on 22/5/2024. At that point, there was a delay of 100 odd days. They have cleared the objections after 1 year in May of 2025. So whether that period, your lordship, what they were doing for 1 year, that there is no explanation for that in the IA, nor has that period been counted. Your lordship has the status on the e-courts.
You file your objection,
Very well. Tried.
heard, Mr.
Dean on.
Nandi Leonard Council for the applicant.
Notices to go
Issue
for the,
notice.
this thing, opposite party respondents number 1 and
I'm
Mr.
preparing for 3, 4 and
K.
5.
Pathak, Leonard Standing Council, APDCL, appears for the respondents 3, 4, and 5. Huh? Petitioner to take steps for service of notice on the respondent 1 and 2 by registered person. Within 1 week, list after 4 weeks.
deep.
Item 5.
Oh, there's no stay. No stay.
My pleasure, your lordship.
Yeah.
My lord, the petitioner before your lordship is an practicing advocate before the idle bench of this honorable court. Pursuant to an advertisement for filling up one post of grade 1 judicial service of Mizoram, she applied. And she emerged as the second successful candidate. My lord. However, eventually it came to light that the first candidate, my lord, she, during the time of her appointment, she was already having grade 3 judicial service. So as per Article 233(2) of the Constitution of India, read with the decision of Dheeraj Moore passed by the Honorable Supreme Court, any candidate who is having appointment in judicial service cannot be directly recruited, as direct recruitment is specifically meant for my lord advocates. However, in the instant case, the respondent authority, that is the High Court on its administrative side, committed another fallacy, that is they have violated the recruitment rules. Rules prescribe that there has to be a select list and an additional list. If the candidate from the select list gets exhausted, then the appointment has to be made from the additional list, which they have not done. And they have rejected my candidature in violation of the rules. That's why today I am praying for a notice, as well as in the meantime, they have issued again, advertisement has been issued the same post, and I am praying for a stay of that advertisement.
That stay will consider on the next suitable date. Let them have instruction.
So my lord, I am appearing on behalf of the
High Court.
respondent number 1 and 2.
Oh,
And so far as my lord interim order is concerned, he has no prima facie case. That's why I am submitting my lord. I have no
Okay.
objection, my lord, regarding issue
Heard,
notice, but
Mr.
prima
J.
facie case is.
Patwari, Leonard Council for the applicant. Stop. Issue notice. No, yeah. Mr. TJ Mahanda, Leonard,
Respondent number 1 and 2. my lord.
Standing Council, High Court, Guwahati High Court, appears for respondents 1 and 2.
I am for number 4.
How about 3? 3 also, you are done?
See, no,
3,
the
Very-
visual bench to be little difficult.
you, difficult.
Notice goes to them.
Appellant, no, MS, B. Bhattacharya, Leonard, additional ID. Mizoram appears for the respondent. Appellant to take steps for service of notice on the respondent number 3 by registered boss.
Yes, ma'am.
Within 1 week. List after 4 weeks. Prayer for entry shall be considered on the next week.
My lord, yeah, third party rights will accrue. My case will be frustrated.
No, it's,
No, my lord, why I am pointing out, he has no prima facie case. Page 37, kindly see, my
no,
lord.
no,
He says that his name should be in the waiting list.
But there is no wait list prepared in the just because of the fiscal management rules, my lord. Nowadays, your lordship kindly see, even in it is included in the rule in the waiting list, my lord. He has no right. That is page 37, my lord. Page 37, clause 7, my lord. Inclusion of the name of the candidate in any list prepared under clause 3. His case is that, my lord, clause under clause 3, her name should be in there. He has no right.
But consideration is a right, my lord.
Yeah.
Lordship will also, then Lordship will make one small observation. Lordship will consider the prayer on my interim prayer on the next day. Okay, my lord. But in the meantime, if your Lordship doesn't give me interim order, I will lose on both counts, my lord. Then without prejudice to my rights assailing this writ petition.
Then you take dusty service on the respond number 3. We'll list it.
I'll take, my lord, but Lordship will also permit me to participate in the new selection, because if I can be
What is
leader
it?
on,
What do you want?
I may be allowed to participate in the new selection without prejudice. to
Yes, my lord.
rights.
He has always.
There's no bar to that.
No.
There's no bar.
They can take they've already submitted. If they
Beginning
if they
because
also
already
make that
second
alter-
advertisement has come. That is the last date of submission is 16th of this month, my lord. Probably he can participate, my lord.
without prejudice to my rights assailing this writ petition, man. And Lordship will
Because there
consider
is
that,
another petition filed, my lord, already by the candidate whose already service has been filed.
Where is the advertisement?
my lord, advertisement it has page, my lord, 87 of the writ petition. The new advertisement that has been essayed.
Oh. The petitioner's appellant is permitted.
My lord, writ petition, not application.
Is a the petition is permitted to participate in the advertisement dated 21st May 2025
Without prejudice.
without prejudice
That-
to her rights in the personal application.
Deeply aware.
Item 6.
May it please your lordship. My lord, here in this case, my lord, Vijay. My lord, the petitioner challenging the appointment of the respondent number 6 in the writ petition, the principal of the college, my lord. There is a selection in pursuant to the advertisement, my lord. There are 3 candidates appeared. 3 candidates appeared, my lord. Your lordship will find it 253, my lord. Page 253, my lord. For the selection of a principal of a particular college, my lord. Page 253.
Yeah.
These are the 3 candidates, my lord. The candidate who secured, my lord, 74.11 is selected, my lord, and writ petitioner
74.11
and writ petitioner that he is getting, my lord, she is getting CL number 2, my lord, 69.96. So she appeared, she challenged this, my lord, my selection, my lord, on the ground that, my lord, the constitution of the selection committee, my lord, she has a grievance against the one of the member. That who is that member? A Buddhist Saikia, there is one member, my lord. That member is simply a BA. So he does not possess any right to become a member of the committee. So that was his challenge, my lord. So in this case, I appeared. There's a affidavit filed by the respondent 5 college authority. They categorically stated that as per the rules, guidelines issued by the government of Assam for the selection of the particularly selection for a principal, there's a guidelines. As per the guidelines, my lord, that was constituted. And my lord, that was not been challenged before this honorable court. But when she came to know that she was not selected, then only, my lord, she opposed this honorable court. So that's why, my lord, there's a preliminary objection raised by the respondent that the person against whom you had made an allegation, he was not made party. The selection committee was not made party, number 1. Number 2, the person against whom there is a specific allegation that he is simply a PA, he cannot be a member of the my lord selection committee. He was not made party. That was a preliminary objection taken by the my lord respondent, my lord. That was recorded by the learned single judge, but no single finding on that, my lord. So then that ground alone, my lord, it is my lord, this petition has to be dismissed, my lord, because there is a preliminary objection that is raised before this honorable court. So you made an allegation against him, you accusing him, but no, he is not without making him party, my lord. Now, my lord, your lordship kindly see the judgment, my lord. Judgment at page, my lord. You also will find it, my lord. Yes, my lord, 213, my lord.
Yeah.
My lord, operative portion from 216, my lord. There are two writ petition which is clubbed together. Almost the pairs are same because my lord, one was filed, my lord, prior to appointment, and one is filed after that, after the approval given by the DSC, my lord. So both are, my lord, pair are same, clubbed together, the common judgment has been passed. Your lordship kindly see page 216, my lord. Para 3. WPC number 265323 petitioner, namely Dr. Gitali Soikia, has challenging the selection of the respondent number 6, namely that.
Are you holding the post of principal?
Yes, my lord. I am holding the post of principal already, my lord. I am working for more than 2 years, my lord. Appointment was made, my lord. 111, my appointment, my lord. page, my lord. I was appointed on 25-23, my lord. Order was, my lord, that was 25-23, my lord.
Okay.
That was my appointment, my lord. I am working, my lord. Now, my lord, it was been set aside by the learned single judge. That's why I am before your lordship. I am challenging the learned single judge, my lord, judgment, my lord. Your lordship kindly see what are the that may I read this, my lord, para 3, my lord. Page 216, my lord. Page another WPC 3229/2000 petitioner Dr. Gitali has prayed for a setting aside the order dated 25/2023, my lord. This is my appointment order. Passed by the respondent number 2. So whoever the respondent number 6 has been appointed as the principal of ACDG College, Nitai Pukhuri Shivsagar, also declared as the selection as unconstitutional, violated the rule and procedure laid down in the Assam College Employees Provincial Election Rule 2010, and also to set aside the selection of procedure pursuant to the interview held on 18/4/2020, and also held fresh selection for the post of principal. Backdrop of the case, backdrop of the fact being the filing of the present petitions are briefly stated as under. The petitioner Dr. Gitali Soikia was appointed as a lecturer in English Department of ACDC College, Nitai Pukhuri, and accordingly she has joined in 1/12/1995. During the course of the service, the CC department was promoted the post of head of the department in English on 1/12/2009, and she has been testing the experience of 27 years with many publishing book and research paper. Thereafter, an advertisement was published on 7/3/2023 for filing of the post of principal ACDC College, Nitai Pukhuri. Accordingly, having fulfilled the requisite qualification and experience, she applied for the post of appointment of the interview on 18/4/2023. Although there is candidates are applied for the post, she fared well in the interview. Thereafter, the petitioner came to know that the selection committee was not constituted as per rule by obtaining an RTI reply application, and then she had submitted an application before the Vice Chancellor of Dibrugarh University, highlighting the defect and malpractice adopting the said process and requisiting the taking necessary action, but the same will fail to over any reason. Thereafter, she preferred in hit petition WPC number to so and so, but this court, where the order that so and so direction was issued to the council for the higher education department, whether the guardian member was included in the selection commission, fixed the matter on 1998. The petitioner is the furnishing a copy of the said order dated so and so, but the respondent number 2, knowing very well that the defect of the selection committee, and without considering the order of this court, passed the impugn order dated so and so, appointment respondent number so and so, and the pleaded case of the petitioner is that constitution of the selection committee by incorporating one member, graduate member, guardian member, namely Sri Vishwadeswar Soikia is a clear violation of the rule, as he is a graduate and a cultivator by profession and nominated as a member of the governing body, and he has no requisite qualification for being appointed as a member of the selection committee, as he was not extended as the academic admission. Academic administration, which is the requirement of the rule, and as such, the very constitution of the selection committee as well as selection process are illegal and violative of the Assam College Employees Provincial Rule 2010. The selection of the respondent number 6 in the appointment of the post of principal education college interview is illegal and arbitrary against the established norms and procedure. And the impugn order the appointment of respondent number 6 passed by the respondent number 2 is liable to be set aside and illegal. The respondent number 1, 2, 3, 4 have not filed affidavit in opposition, but the respondent number 5, the president governing body of the ACDC college, has filed affidavit in opposition denying the statement and amendment made in the petition. The said affidavit, the respondent number 5 has taken a stand that the writ petition are not maintainable on the ground of that. Firstly, the petitioner has challenged the selection of the respondent number 6 after the participation in the interview held in 18/4/2023 without any protest and after being unsuccessful. And secondly, the scope of judicial review of the court in matter of selection is limited and except on a ground of malified or violation of statutory rule, that the recommendation of the selection committee cannot be challenged, and the petitioner has failed to demonstrate of any such violation of statutory rule malified on their part of selection committee. Thirdly, there is a disputed question of fact regarding the experience of this expertise of the members of the selection committee, which cannot be adjudicated in a writ proceeding. Another step taken by the respondent 5 is that the selection committee has not been arrayed as a party in being the selection proceeding, and due to the non-joinder of necessary party, the petitioner is liable to be dismissed. That was the ground taken, my lord. It is also stated that all the norms of selection principle of the provincialized college are prescribed in Director of Higher Education Assam has duly been followed. And the allegation leveled against the petitioner is afterthought, and she did not raise any grievance against the governing body nominee member in respect of his expertise in academic administration, except his qualification that became a guardian member. And she has taken a contrary stand in that she was aware about the selection of the respondent number 6 principal Haji College, and no precautions whose policy was adopted while selecting the respondent number 6, and the selection was done in the transparent manner. He further stated that Bodheswar Soikia was not a guardian member of the selection committee. Instead of, he was the nominee of the governing body of the ACDC college, having educational qualification of graduate in art. In the process, the requisite experience of the educational administration of the college and the inclusion of Bodheswar Soikia as one of the member of the selection committee has not been challenged, and therefore it is content there to dismiss the petition. Submission. Mr. Phukon learned counsel for the petitioner submit that the appointment of principal of provincialized college in the governing body of rules 2010 in contravention of the said rule, the selection committee has been constituted the selection of the principal ACDC college. Mr. Phukon also submit that it is a fact that the petitioner has participated in the selection process, and after
yeah, we can go to that then.
my lord. No, my lord, your lordship kindly see that your lordship. My lord. Yes, my lord. That line, my lord, is very important. That's why I'm reading, my lord. The Mr. Phukon also submitted is a fact that the petitioner was participated in the selection process, and after participating in the process, he had applied for the information about the constitution of the selection committee by filing an RTI application on 24/20, while the interview was held on 18/4/2023, and only after receiving the reply RTI, she came to know that the educational qualification of the guardian member of the ACDC college governing body is a panel interview is a VA. That is absolutely wrong finding, my lord. Wrong submission and wrong finding also. Because he knows that he is a BA, that she says that after my lord filing RTI application, she came to know. But it is wrong, my lord. Because in her representation, my lord, earlier, herself stated that, my lord, so and so is a BA. So that is, my lord, absolutely wrong finding and wrong submission, my lord. In her representation, he clearly mentioned that so and so member is a BA before filing RTI application, my lord. So, my lord, it is page 128, my lord. I will come to that, my lord. Now, my lord, your lordship kindly see. First thing, my lord, your lordship kindly see, there is a clear, my lord, preliminary objection has been raised by the respondent authority that the person who was the member, the Bodheswar Soikia, against whom he made an allegation, he was not made party. But learned single judge, my lord, totally ignoring that, my lord, nothing has been done, my lord. No finding has been given on that point, my lord. So that is my first point, my lord. Second point, my lord, your lordship kindly see, he has taken a participate, he is waiting for the result. The same, my lord, same selection body, if he selected, she selected, my lord, definitely she has no grievance. But now no, she has not been selected. Now he is stopped from, my lord, participating in his process, challenging, my lord. This is my second submission, my lord. Because the citation which was, my lord, shown by him, my lord, these are, my lord, citation, they are not applicable to the present case, my lord. Because in one, my lord, judgment that is considered by, my lord, single judge, my lord, that page 249, my lord, page 249. I have carefully page 249, para 33.3. I have carefully gone through the decision to referred by Mr. Gogoi, Lanet Standing Council, respondent number 1, 2, and 3, regarding how a view of the decision began so and the so. In case of Jagdish Prasad Sharma, and the court is in the view that the decision referred by the Mr. Gogoi, instead of advancing the judgment, strengthening the argument of Mr. Fukon and Lanet Council for the petitioner. That finding also, my lord, this judgment is in favor of the defendant only, my lord, respondent only, not, my lord, that I'll place, my lord. Now, my lord, your lordship kindly see the judgment, my lord, regarding point of estoppel, my lord, the which judgment was relied by the learned single judge, that is, my lord, AI 1997 Supreme Court 2000, AI 1997 Supreme Court 2110. That is the judgment, my lord, regarding, my lord, 2110. But SCC court, in that judgment, my lord, what happened? I'll distinguish that, my lord. In that judgment, my lord, there is a rule by the 1995 rule. In 1995 rule, my lord, procedural selection procedure is prescribed. But government, my lord, not the government, my lord, by issuing a notification, they just made a selection committee. And accordingly, selection committee, my lord, selection was made, my lord. Then those who are, although they are appearing, they say that yes, when there is a rule, there is an act, you cannot constitute a selection committee by way of notification, defying the rule. That's why, my lord, in that case, my lord, is a clear that constitution of the selection board was not as per rule. Here in this case, what he projected, my lord, the one member, he is simply BA, he cannot be taken as a expedite in administration. So I will come to that, my lord, selection board, my lord. So that which was relied by the learned single judge, that I mean, but pattern of decision, a series of decisions, even, my lord, three judgments decision right from 1976, my lord, that the person who was appearing in the interview, he cannot challenge the, my lord, constitution of the selection committee. So I will come to that now. Before that, your lordship kindly see page 251, my lord.
Yeah.
Page 251, my lord, that is the guideline, that is the guiding factor of, my lord, state of Assam to appoint regarding appointment of the principal. Page 251, my lord. Exercise of the power conferred on, as your lordship, what is 251? Exercise of the power conferred under section 1 of the section 12 of the Assam State, Assam College Employees Provincial Rule. The governor of Assam is hereby pleased to make the following rule. Further to amend the Assam College Employees Procedure Rule, therefore, FR is a for his center. The rule is called the Assam College Employees Provincial Amendment Rule 2017 for came to be enforced, my lord. Amendment of section 3, my lord. The principal rule 10, existing rule 3A and so and so, that there shall be a selection committee for selection of the post of principal by direct recruitment of the various provincial colleges. The selection committee shall be consist of following: vice chancellor of a affiliated university, president of a governing body of the college, one member of the vice chancellor of the vice chancellor who shall be in higher education department, one nominee of the vice chancellor. That is there. One member of the governing body, one nominee of the governing body of the college who shall be the expert in academic administration. So that, my lord, he must be a member of the governing body of the college, and he shall be an expert in, my lord, academic administration. So the person who was appointed here as a, my lord, that Budheswar Soikia, he was in governing body and for last 3 years, and he was nominated as a member of the nominee of the governing body, my lord. So his credential, his expertise is, my lord, is questioned by the was challenged before the honorable court. Again, I am submitting, but he was not party member before the honorable court. Now, my lord, your lordship, kindly see, my lord, another aspect of the matter. Last line, very last line. The page 252, my lord. Provided that at least 5 members, including 2 experts from clause 5, but above shall constitute the quorum. So here, my lord, even 5 members is enough. Even 1 member is, my lord, thrown out, my lord. Even then, my lord, selection committee will not be, my lord, vitiated, my lord. Because your lordship kindly see that she has raised a question of bias against Budheswar Soikia. But what mark given by Budheswar Soikia to me and what mark given to Budheswar Soikia to her, my lord? Only, my lord, same mark, absolutely same mark. Only 0.01 difference, my lord. Your lordship kindly see page 253, my lord. Page 253, my lord. Column number, my lord, 1, 2, 3, 4, 5. Governing body nominee. So that person awarded to the writ petitioner 74.96 and to the appellant, my lord, 74.97. 96 and 97. 0.96 and only, my lord, 1 difference. So against, my lord, against that person, my lord, bias and not competent, everything is there, my lord. So my submission before your lordship, this, my lord, another aspect of the matter, my lord, if this learned single judge order is allowed to stand, then, my lord, it will be a very far-reaching effect, because there are 2 findings, my lord. One finding is that there are 3 findings, my lord. One finding is very, my lord, dangerous to, my lord, other college and other selection, my lord. So your lordship kindly, my lord, issues, my lord, that issues, your lordship kindly see page 224, my lord. 224, my lord.
Yes.
The issues before this court, the view of this statement and environment made in pleading, and also the view of the CIFL submission so advance the bar, the issue of the decided in Shanko. Whether the constitution of the selection committee for selection of the principal of the HCDC college was in accordance with the clause 3(4) of the rule 10 of the Assam College Employees Provincial Act 2005 as amended, and that notification on 9 should also be accordance with the UGC guideline. Number 2, whether the candidate having appeared in the interview and taking part in the selection process can turn around and challenge the selection process because of stoppel. Whether the UGC guidelines are binding on the state government. So that finding, my lord, regarding fee, my lord, only, my lord, 1 and 2 I have argued, my lord. I'll highlight, my lord. But your lordship and issue number 3, my lord. Para 33.3 and 33.4, my lord. May I read it, para 33.3, my lord? Page 249. I have carefully gone through the decision so referred by Mr. Gogoi. Learned standing concept of respondent number 1, 2, and 3 in this regard. However, in view of the decision in so-and-so Ghabri and Koilani Matthew, And the case of Jagadish Prasad Sharma and so, this court is of the view that the decision referred by the Gogoi, instead of advancing the argument, strengthened the argument of Mr. Fupon and learned counsel for the petitioner. But that finding is, and next paragraph, the 33.5, in view of the above discussion, the finding is, finding the issue number 3, that means whether the UGC guidelines are, my lord, binding or not, my lord, as formulated herein above is answered affirmative in appropriate terms. So, my lord, your lordship kindly see, there are division bench judgment of our High Court. There, that in fact, the judgment which was, my lord, cited by Mr. Gogoi, my lord, that was, my lord, the learned single judge says that in fact that judgment held, my lord, petitioner, not respondent, my lord. That finding is wrong. Why I am the finding wrong, my lord? I'll just place the judgment, my lord. No, Quilani. Judgment. And our division bench judgment also, my lord. This is our division bench judgment, my lord. Justice Suman Shyam judgment, my lord. Chief Justice and Suman. One more, one more. So, Pulen. My lord, you state where you're. Considering those judgment, my lord, para 23, my lord. There is a division bench judgment, our High Court, my lord. After para 23, my lord. After going through the impugned judgment of the learned single judge, we are therefore the unhesitated an opinion that the learned single judge was wholly justified in holding that UGC regulation 2010 would not have any binding effect on the state of government of Assam, since those have not been adopted by the state. So there is a clear finding given by this honorable court by the division bench. So that issue number 3, which was decided in favor of the petitioner, my lord, that is directly contrary, my lord. So if it is allowed, my lord, now from your lordship kindly that the single judge judgment is allowed, then, my lord, all the UGC guidelines, because UGC guidelines are, my lord, they are, my lord, followed by the central government, my lord, central university, and those colleges who are directly, my lord, funded by the UGC, my lord. These are provincialized colleges. Salaries has been paid by the state of Assam. So that finding, my lord, it is absolutely, my lord, your lordship kindly goes to, my lord, but probably, my lord, the education department will be in trouble, my lord. So there, if there is a question arise, the issue which was framed, which was already decided by the division bench, my lord, how they can, my lord, taken into consideration for, my lord, deciding the issue. So now my submission before your lordship, my lord, your lordship kindly the point of Istobel also, my lord, once he appeared, that, my lord, there is a very clear judgment of the 2000, my lord, 73 judgment. Huh? There is a, my lord, English condition, no? My lord, your lordship kindly see 1976 Supreme Court 2423. I have given a book list, my lord.
Book list. AIR.
AIR 1976 Supreme Court.
You don't have this.
AIR 1976 Supreme Court 2428. This is a 3-judge bench judgment, my lord. Exactly similar to our case, my lord. Because here, my lord, Constitution of Selection.
2428.
2428, my lord. Para 15, my lord. Para 15, my lord. That is regarding Constitution of Selection Committee, my lord. directly, my lord, para 15.
Yeah.
So my submission before your lordship. My submission before your lordship, kindly, my lord, it will may be admitted, and my lord, I may be protected by way of my appropriate interim order, because one, my lord, your lordship, I have already read that, my lord, that when there is a preliminary objection raised regarding non-joiner of necessary party, that was not been answered. That was, if there is a submission recorded, my lord, no finding has been given.
Yes, Fukan.
Lord, I take your lordship straight to the impinge judgment. Page 224, the issue, paragraph 12. Page 224, paragraph 12. The issues. I'll read slowly. In view of the statements and environment.
This we have already gone through. This we have gone through.
Milord.
We have already gone through this one.
Oh, Milord. So, Milord, there are three issues. First, whether that select committee for selection of principal is in accordance with the UGC guidelines. Milord, that is very important issue. Second, whether candidate having appeared in the interview taking part would challenge. And third, whether UGC guidelines are binding on the state government. So, Milord, I will take up the issue number 3 first. That will have the impact of the, Milord, this entire proceedings. First, Milord, my learned friend just, Milord, referred this division bench judgment in Srimoy, paragraph 22. He just referred. There is a vital difference between UGC regulation of 2010 and 2018. Paragraph 23. I'll read slowly. After going through the paragraph 23 minute,
Yeah.
Srimoy Bordely case, internal page 14. After going through the impugned judgment of the learned single judge, we are therefore of the unhesitant opinion that the learned single judge was wholly justified in holding that the UGC regulations of 2010, you know, kindly mark those words, UGC regulations of 2010, I will clarify them, would not have any binding effect on the state government of Assam, since those have not been adopted by the state. The mere mention of some of the provisions of the regulation of 2010 in some notifications issued by state government of Assam cannot be stretched to such an extent for the court to hold that the same was sufficient to conclude that the guidelines had been adopted by the state government in its entirety. The said opinion is further emboldened by the undisputed position of fact that the colleges in question, next page, Miller, are entirely run by funds provided by the state government of Assam, practically without any financial assistance from the UGC. So, Milord, this division bench judgment is entirely regarding UGC regulations of 2010. Now, if we come to Jagdish Prasad case that has been referred in the honorable single judge's judgment, Milord, and which has been relied by my learned friend, Mr. Gogoi, Jagdish Prasad Sharma and others. Jagdish Prasad, Milord. Milord, I have got the copies, Milord. I have got 2 additional copies, Milord. It will just. This Jagdish Prasad case of the Supreme Court by 3 judges bench is regarding 2010 regulation. Now kindly, I'll be very short, Miller, kindly turn to para 12. 9 and 12. Para 9, Miller. Page 641. The most important development at a relevant time, para 9, Miller, since it's very, Miller, crucial regarding the difference between 2010 regulation and 2018 regulation. In 2010 regulation, there was an option given to the state government, and in 2018, there is no option, Miller. It is an option regarding the, Miller, the upgrading the age limit from 62 to 65 years. And the state government's role, whether that scheme with 80% Miller grant from the center could be Miller received by the state governments or not. That was an option in 2010 regulation. On the basis of that, Miller, this Jagdish Prasad Miller case has been Miller rendered. Para 9. I'll read slowly. The most important development at the relevant time, however, was the issuance of a letter by the central government in the Ministry of Human Resource Development Department of Higher Education to the Secretary UGC on 31/12/2008. It is important, that date. Regarding a scheme of revision of pay of teachers and other equivalent cadres in all the central universities and colleges and deemed universities, following the revision of pay scales of the central government employees on the recommendation of the 6th Central Pay Commission, subject to the all conditions mentioned in the letter and the regulations. The state governments were given an option. It is important. The state governments were given an option to adopt the scheme in its composite form. Now, para 12. Para 12. Next page. I'll skip the other parameter. Para 12. Clause PV of the said para 8, which is equally relevant, is also extracted herein below, under quotation. PV. It is in the UGC regulation of 2010. This scheme may be extended to universities, colleges, and other higher educational institutions coming under the purview of the state legislatures, provided, it is important, provided the state governments wish to adopt and implement the scheme subject to the following terms and conditions. So it is regarding the wish of the state government to adopt that scheme. If the state government does not wish, then Miller UGC regulation 2010 cannot be Miller implemented. Miller, now kindly turn to para 78. First 71. The development of law and the difference between 2010 and 2018 regulations. Miller, it is to be Miller in the context of that Miller, these judgments may be Miller enunciated. 71 para page 660. In the instant case, said questions do not arise inasmuch as mentioned herein above, the acceptance of the scheme in its composite form was made discretionary, and therefore there was no compulsion on the state and its authorities to adopt the scheme. The problem lies in the desire of the state and its authorities to obtain the benefit of 80% of the salaries of teachers. At that time, Miller, that was given, Miller, and other staff under the scheme without increasing the age of retirement from 62 to 65 years. That was the aspect, Miller. Or the subsequent condition regarding the taking over the scheme with its financial implications from 1/4/2010. Now we can skip the other para 78. Page 663. Para 78. We are then faced with a situation, para 78, where a composite scheme has been framed by the UGC, whereby the commission agreed to bear 80% of the expenses incurred by the state. If such scheme was to be accepted, subject to the condition that the remaining 20% of the expense would be made by the state, and that on from 1/4/2010, the state government would take over the entire burden. It is important, my lord. On and from 1/4/2010, the state government would take over the entire burden and would also have enhanced the age of superannuation of teachers and other staff from 62 to 65 years. That was not done in the state of my lord, Assam. There being no compulsion to accept and or adopt the said scheme, the states are free to decide as to whether the scheme would be adopted by them or not. In our view, there can be no automatic application of the recommendations made by the Commission, that is UGC Miller, without any conscious decision being taken by the state in this regard on account of the financial implications and other consequences attached to such a decision. The case of those petitioners who have claimed that they should be given the benefit of the scheme divorce the responsibility attached thereto must therefore fail. So, as per 2010 regulation, my lord, it's all right that the state government would adopt that regulation or may not adopt that regulation. And in case of state government of Assam, that scheme was not adopted. So as per that UGC regulation 2010, it is, my lord, directory, not mandatory, which has been, my lord, waived in later regulation. My lord, the regulation of 2010, only one page, my lord. I have only one copy, my lord. Only one page, my lord, appendices. This central government scheme giving option to the state governments have been incorporated in the 2010 regulation as appendix number 1. But in 2018 regulation, this is not there, my lord. So my humble submission would be, my lord, 2010 regulation regarding that scheme is optional. So this Jagdish Prasad case came up. But after 2018, that Gambhiran case, applying the, my lord, law of repugnancy, my lord, it is not optional. It is mandatory to the central colleges, central universities, as well as state colleges and state universities. That is very crucial. Now we come to the Kalyani Mathavinan case. It is 2013 case, Jagdish. Now Kalyani Mathavinan of 2015. Okay. Relying upon constitutional bench judgment regarding law of repugnancy.
We have
Hey, Harry. Para 51. I'll try to be very brief, my lord. Para 51. First few lines. Kalyani Mathavinan, 2 judges bench. In Preeti Srivastava versus State of MP, a constitution bench of 5 judges dealt with the state competence under list 3 entry 25 to control or regulate higher education which is subject to standards laid down by the Union of India. The court noticed that the standards of higher education can be laid down under list 1 entry 66 by the central legislation and held as follows. The legislative competence of Parliament and the legislatures of the states to make laws under Article 246 is regulated by the 7th schedule to the Constitution. In the 7th schedule, as originally in force, entry 11 of list 2 gave to the state an exclusive power to legislate on education, including universities, subject to the provisions of entry 63, 4, 5, and 6 of list 1 and entry 25 of the list 3. Entry 11 of list 2 was deleted and entry 25 of list 3 was amended with effect from 3/1/1977 as a result of the Constitutional 42nd Amendment Act of 1976, the present entry 25 in the concurrent list is as follows. 25. Education, including technical education, medical education, universities subject to the provisions of entry 63, 4, 5, and 6 of list 1, vocational and technical training of labor. Entry 25 is subject inter alia to entry 66 of list 1. Entry 66 of list 1 is as follows. Coordination and determination of standards in institutions for higher education or research and scientific and technical institutions. Now we can skip the other parameter. It is a constitution bench judgment in British Srivastava that legislative competence of parliament has been given. Now, explain Miller. Now, para 53. It has been relied subsequently in Gomhidan case. Para 53. Only 4 lines. The aforesaid judgment makes it clear that to the extent the state legislation is in conflict with the central legislation, including subordinate legislation made by the central legislation under NT 25 of the concurrent list, shall be repugnant to the central legislation and would be inoperative. So relying on particularly this para 53, Gomhidan in 2022, Miller.
Come to para 62.1
62.1
of the same Kalyani.
Placitum A, last base. To the extent the state legislation is in conflict with the central legislation, including subordinate legislation made by the central legislation under NT 25 of the concurrent list, shall be repugnant to the central legislation and would be inoperative.
Read further down.
The UGC regulations being passed by both the houses of parliament, though a subordinate legislation has binding effect on the universities to which it applies. The UGC regulation 2010 are mandatory to teachers and other academic staff in all the central universities and colleges thereunder, and the institutions deemed to be universities whose maintenance expenditure is made by UGC. 62.4. The UGC regulation 2010, it is important, are directive. It is in the context of 2010 regulation. Till then, Miller, the 2018 regulation has not been promulgated. The UGC regulation 2010 are directory for the universities, colleges, and other higher educational institutions under the purview of the state legislation, as the matter has been left to the state government to adopt and implement the scheme. That scheme, that option from 62 years to 65 years retirement age, and the 80% fund assisted given by the central government. So it is directory, and UGC regulation 2010 are partly mandatory and partly directory. The next 62.5. The UGC regulation 2010 having not been adopted by the state of Tamil Nadu, the question of conflict between the state legislation and the statutes framed under the central legislation does not arise. Once they are adopted by the state government, the state legislation to be amended appropriately. In such case, also there shall be no conflict between the state legislation and the central legislation. That is why, Millard, in the cases, several cases are there. It has been, given that it has been opined by this Honorable Court also and the Apex Court also, that UGC regulation 2010 is directory, not mandatory. But now, after promulgation of 2018 regulation, 18 regulation. Only one page, this 2018 regulation. The difference between 2010 regulation appendixes and 2018 regulation appendix. I have only one copy,
Yes.
There is no scheme of 2008 Miller, which was in the 2010 regulation. That scheme of the central government of 2008 regarding that optional scheme is not there. So after 2018, vital difference below. In 2010, there was an option to the state government. But in 2018, there is no option. That is why this Gambhidan has come. That it is not not directory, now mandatory. All the universities, all the colleges of the entire nation would be guided, mandatorily guided by the UGC. There is no option left. That is why this Gambhidan came. Applying the repugnancy principle, Miller, as enunciated in Priti Srivastava and Pelani Mathavina. So now we come to the
What is this got to do?
judgment of Gambhidan. Gambhidan has been applied in so many cases, Miller, even after 2022.
What?
No option, Miller.
Where is the option here in the 2010, in this appendix 1?
Miller.
In appendix 1, what is the option? There's no option.
There is option, Miller. I have given the Miller.
2010.
2010.
Oh.
There was an option to the state.
Option is there, but then in this appendix 1, what is the option? There's
Miller,
no option here.
2010 regulation, there was an option, Miller.
There's an option, that's
But in
fine, we
2000
understand that.
Miller.
But you're referring to the appendix 1, isn't it?
Yes, Miller. That was in the Jagdish Prasad case, Miller. But in 2018 regulation, there was no optional scheme, Miller. That's the difference. There's a minor, Miller, aspects, Miller. That is why
That will have to consider later on.
Miller, Gambhidan came, Miller. Then after Gambhidan, Miller, everything is mandatory, Miller. And if mandatory, then Miller, the proceedings of this honorable court under Gambhidan, Miller, that regulation, the selection committee, it would be mandatorily guided by the UGC regulations. That's my point.
Where is the 2018?
2018 regulation. In the last portion, Miller, appendix part. May I read, page 101. It's a fitment table, assessment criteria, only this appendix 1 and 2, nothing else.
Where is this MHRD notification of 8/11/2015?
Next page, Miller, appendix 1.
Oh.
Miller, it is of 2017, Miller.
Hmm.
Scheme of revision of pay of teachers under 7th Central Pay Commission. It is not, Miller, similar to the earlier regulation 2010, 2008.
No, in this appendix 1, in the 2018 regulation,
Miller,
you have a copy of this.
Miller.
It says fitment table fixation of pay of existing incumbents who were in position as on 1/1/2016 in various categories of post indicated in the MHRD notification letter corrigendum so and so 8/11/2017.
Miller.
Who is that notification?
Miller, that notification.
Only that one only
Miller, it is after 2018, Miller, and it refers to 2017 corrigendum, Miller.
Oh,
But it is not about that 2008 optional scheme, Miller, notification of central
that's
government.
why 2017 only that list is there. Various categories of post indicated in the tables.
So this notification does not signify, does not indicate that it is optional to the state government. Milord, that optional aspect,
Understand what
Milord.
you said.
2010 regulation is regarding that optional scheme.
But 2010,
In 2008.
we know that there was an option given.
Milord, but here,
The state of Assam did not adopt
Adopt.
that option.
Milord.
Clear. 2018,
So that is why, Milord, 2018 Gambhidan case will, Milord, prevail, Milord.
let us see what case is the.
Gambhidan case, Milord.
Understand.
2022, Milord.
20,
2022 5 SCC 179. I'll start from para 48, Milord. Since it's very crucial to the present proceeding, Milord. Para 48 to 51, Milord. Page 205. Para 48. It is clear that the respondent state of Gujarat has failed to take note of the communication from the EGC, and instead the respondent university has left it to the sweet will of the search committee to prescribe eligibility criteria for the appointment of the vice chancellor of the university. The eligibility criteria, when once fixed by the EGC under its regulations, would, in our view, it is important, Milord, apply to all the universities which are aided by the UGC to be bound by the said regulations. Even, Milord, there are several paras, Milord. It is not only one aspect that aided by UGC. If it is not aided by UGC, then what, Milord? That law of repugnancy, Milord, that 5 judges British Srivastava case, Kalyani Mathavina. Said regulation,
Kalyani was something else.
Milord, in Kalyani, Milord, that British Srivastava explained that applying the law of repugnancy, Milord,
Why are you forgetting the findings of the court?
but that was, Milord, partly mandatory, partly optional in view of 2010 regulation.
No.
So that is the ratio, Milord. It was in the context of 2000 regulation, but in the context of 2018 regulation, what Gambhidan says. Next page, Milord. Said regulations, even in the absence of the same being incorporated under the respective Universities Act of the respective states. Now 49. Therefore, when the appointment of respondent 4 is found to be contrary to the UGC regulations 2018, and the UGC regulations are having the statutory force, we are of the opinion that this is a fit case to issue a writ of quo warranto and to quash and set aside the appointment of respondent 4 as a VC of the SP University. Next page, next parameter. It is very important. It cannot be disputed that the, I'll read slowly, Milord. It cannot be disputed that the UGC regulations are enacted by UGC in exercise of powers under section 26(1)(e) and 26(1)(g) of the UGC Act 1956. Even as per the UGC Act, every rule and regulation made under the said Act shall be laid before each House of Parliament. Therefore, being a subordinate legislation, UGC regulations becomes part of the Act. In case of any conflict between the state legislation, it is very, very important, Milord, in this present proceeding, Milord. In case of any conflict between the state legislation and the central legislation shall prevail by applying the rule principle of repugnancy as enunciated in Article 254 of the Constitution, as the subject education is in the concurrent list 3 of 7 schedule of the Constitution. So, if there is a conflict between the UGC regulation and the state notification, then which will prevail? As per Gambhidan,
Provided they are aided by the UGC.
Milord,
That's it.
then Milord, this Milord para 50, law of repugnancy, aided or not aided, Guwahati University has also adopted this 2018 regulation. And Dibrugarh University has also adopted this 2018 regulation. And if not adopted, Then also, my lord, since it's a mandatory nature of the existing regulation of 2018, as per this Gambhiran case, if there is a conflict between state government notification and the EGC regulation, then EGC regulation will prevail. That is clear law, my lord, laid down in Gambhiran case. My lord, since this division bench is like Supreme Court to us, my lord. So, my lord, some finer nuances, some finer differences are there, my lord.
These methods. Yeah, go good. We'll admit. We'll admit and state.
My lord, one thing, my lord, since my learned friends in the government has not challenged this, my lord, judgment, technically, my lord,
We
he
also file,
supports
we
me.
also file appeal, lordship. We also file appeal regarding this.
Right now, my lord, no appeal has been filed, but I agree with my learned friend, my lord. But anyway, my lord,
Just I pointed two things, lordship.
my lord,
Permit you.
but regarding that stay, my lord, may I submit, my lord, regarding that stay, my lord, 2 years gone, my lord.
Okay.
That illegally constituted, my lord, selection committee selected that principal, my lord. So, my lord, regarding that interim order, I will submit. my
Fix
lord.
the date. Oh, final hearing.
Sorry, what can I say?
With pleasure, lordship. Otherwise, law is very clear, lordship, regarding participation part and lordship, this is binding part. Participation part, I place one recent judgment of the honorable appeal.
That part.
That is part there, key judges bench judgment, lordship, Ashok Kumar case, that is there. It's a settled proposition of law. Once you have participated and rendered before the selection committee, now you cannot turn around. Otherwise, lordship, the binding principles, lordship, the dictum given by the Kalyani Mativedam, paragraph 62 is still holding in the appeal, lordship. It is reiterated in the 2024, even lordship, January 2025 by the honorable apex court. In January 25, lordship, it is in K. Bijoyan case also, honorable Supreme Court says, even Sudhir Budhakoti case, it is come after the lordship Gambhiran. It is also honorable Supreme Court says that until and unless it was adopted by the state, it is not binding to the state lordship. This is the principles holding in the appeal lordship. And regarding that 2010 and 2018, I just clarify also one thing. The petitioners only placed that particular appendix lordship. 2010 regulation does not consist only the appendix lordship. It is the scheme formulated as per UGC Act 1956, and this regulation was done as per Section 20 of the UGC Act lordship. It is the minimum standard criteria should be followed by the college and universities lordship. Holding the equivalent, lordship, the required qualification part and other part selection, everything is a combined process lordship. It is a combined as a whole lordship. And that particular scheme is as a part of that particular regulation lordship. The Honorable Supreme Court in Jagdish Prasad case itself says that in his assessment lordship, until and unless it was adopted by the state, it cannot be binding to the state. And that was reiterated time and again. So at this stage, my PRS lordship may get order, Honorable Learned Singular order is lordship by the violating the dictum given by the Honorable Apex Court lordship. So lordship may issue notice and state lordship, and even state also going to file an appeal lordship. And the particular persons holding the post of principal last 2 years. And the view of the honorable single judge is that UGC regulation is binding. It is a totally contrary view given by our High Court division bench as well as the lordship, the judgment given by the honorable Supreme Court. Various judgment lordship. Gambhiran judgment is on the basis that lordship, the UGC's regulation was adopted by the state. Only one paragraph lordship may kindly pay. Gambhiran judgment lordship. Paragraph 28 and 29 lordship. Paragraph 20, only one paragraph, paragraph 29, Lordship. Your Lordship, I can read it, Lordship. It is not in dispute that the SP University is receiving central financial assistance under the scheme. It is included in the state universities receiving central financial assistance as per section 12B of the UGC Act, and therefore having adopted the UGC scheme, Lordship. They have adopted it, Lordship. State of Gujarat has adopted it, Lordship. And here the case is totally defined, Lordship. At no point of time, State of Assam has adopted the UGC's regulations, Lordship. And no, there is no any central fund regarding the, even we have filed the affidavit also, Lordship. In the division bench, Lordship, we are not taking a single penny for salary and other parts, Lordship. All are borne by the state exchequer, Lordship. So, Lordship, this judgment is not applicable here. Even that was, Lordship, after that, after the Lordship Gambhiran judgment, Sudhir Budakoti's judgment is also come, Lordship. It is, if Lordship permit, I can place that judgment also, Lordship. Sudhir Budakoti's judgment also in the similar line.
Third, Mr. T.G. Mahanda, Learned Supreme Court. Assistant Learned P. Sharma, Learned Court. Admit. Who are the respondents, please?
I'm for voting one.
2 and 3.
Two, three, Lordship.
Okay, go good.
4 inspector of colleges, Assam.
No, no,
Only
no.
that.
Lord,
You have for one.
Milord, we have pointed out only one aspect, Milord. Page 202, Milord.
I'm issuing, I'm only dictating my order.
Milord, only that, Milord, that appointment letter, Milord, one vitally crucial, Milord, aspect is here, Milord. I'll take only 2 minutes, Milord. Page 202, Milord.
Oh.
The appointment letter.
Oh.
It has been, Milord, it is an order dated 20 May 2023. Birinsi Kumar Bora, the appellant, has been appointed, Milord. Kindly turn to copy to that 4 down below. The president governing body so and so, with reference to his letter dated so and so, it is important, Milord. He is directed to certify confirming that there is no court case against the said post incumbent. 3 cases are pending. This writ is still, Milord, continuing, but he has been allowed to continue.
When did you file your writ petition?
Milord, way back in 2023.
Date.
Filed on 4/5/23, registered on 12/5/23, first case. Notice of motion was issued on 17/5/23. The case has come up before this Honor High Court, Milord, for 11th time, Milord, and no affidavit has been filed. In the second case, so, Milord, these 3 cases are pending. The state government as well as the private respondent is also aware. No affidavit has been filed. And in spite of that, Milord, 11 times, both the cases have come up before this honorable court. 4 days heard hearing, Milord, was going on, Milord. So, Milord, in view of this, Milord, pendency of the case, he should not have continued, Milord.
This is not a condition. This is a certificate.
So, Milord, the governing body, Milord, is aware about the pendency of this case, but he has been allowed for last 2 years, Milord. Only 5-year term, Milord.
There is no stay order in any case. Pending cases is no bar. It is bar.
Mr. Gogoi, you are appearing?
And for 20, Lord.
No, it's something also higher. Yeah, so it's for 2 and 3. Inspector of colleges?
There is no system, Inspector of Police. And because it was till the party and it becomes that.
Mr. R. Majumdar, Learned Supreme Court. 5 and 6. Five, and Mr. Let us also that way to respond. Huh? Yeah. This will give a short date. If you want to file your affidavit, you can file. If you don't want to file on the basis of the pleadings in the writ court. I think normally in the writ appeal,
It will be admitted.
Affidavit, my lord.
It has to be admitted, madam. It is appeal, madam. It is regular appeal.
So, my lord, next week, a date may be fixed, my lord. Otherwise, my lord,
list the matter for hearing. Or next week, there will be something on 17th of June.
my lord, on that day, my lord, attendant
That's
maybe
why I'm
made
saying for hearing
for disposal, my lord.
till the next suitable. The just been not. Dated. 1/5, maybe 5. Was 5/8, Leonard. Single judge in the 265 here. And the 3298 of. Sorry, of state.
Most of it.
Develop.
Item 7 and item 1 for production.
IA has come, my lord.
Yeah, I am the caveator, my lord. I want to file an objection to this. I have the caveat, my lord. If it was already filed, I has filed today, come. I want to file, pray for some time to file written objection to this step here. my lord.
But yeah, but we are then the top for the apply. Then I'll issue not.
My lord, here, my lord, there is a interim prayer, my lord. Actually, what happened, why I have to file the IA is that, my lord.
He wants to file an objection.
My lord,
Let him
that
file.
that I'll satisfy also. My lord, out of the typing mistake, my lord, the interim prayer part was left out, for which I had to file additionally the stay petition.
Fine, that's fine. That's fine. That's
But
fine.
they are enjoying, my lord, benefits, my lord. Lordship fixed the short date, my lord.
I'll-
My client is at my lord Lakhimpur.
My client is also, my lord, in not Lakhimpur, not in Guwahati.
Yes, sir.
Very good. File that through.
It's on Friday, my lord.
Issue not.
For consideration of interim.
No, my lord, I have filed objection. List.
Higher education. Mr. A. Tableton and standing council higher education appears to respond, opposite party.
I am for respondent. 9.
No. 1, 2, 3. 1, 2, 3.
Full IA.
I have numbering ki man.
1771.
1771.
Huh? 1, 2, 3. 1, 2, 3, 5, 6. Finance. Mr. Italian and the standing council finance appears to respond number 4. And Mr. A. Sibabura and the senior council executed by.
And they.
And they appears to respond. Good, 9 and 12.
In 2 weeks,
But
I'll
this
file.
will have to go to 7 and 8 also.
My lord.
Applicant takes step. Or the responsibility made by the district court.
Made.
Rest as well as Dasti, my lord.
For additional, yeah, applicant.
We are going to take care. Maintain.
On the important made by the secretary to the district court within 1 week.
My lord, 10 days, my lord, give.
But I don't get
They want to delay, my lord.
within 1 week.
They are receiving salary.
Minimum notice.
Draft applicant shall file the affidavit with the
IA is the part of the main writ appeal, my lord.
Anyway, I'll file objection, my lord, give a reasonable time.
Which the LC for well done. Your part. Applying for respondent 9 and 10. So it's for 10 days time.
10 days time.
No, they don't have to 5 10.
David today, miss case, man.
You want to file objection?
Yes, object.
It is allowed. List of. Okay. 16. 16th of.
16th of June.
Lordship.
No, no, Luana Dasti.
That's fine. It is all right, all of you.
My lord, just a minute, my lord, just a
Just take your date.
কি আছে 10 কি আছে হ্যাঁ
Can it be an 18, man, 18,
10 কাবেরি কো এটু
18?
লম টু well lordship has issued notice on respond number 10 also, my lord. There is
Oh,
a
yes,
next page, there is a 10. He is appearing for the 9. 10 is also there.
Oh, you are appearing for 9 and 10, isn't it?
No, no, only 9, man. 10 is
Oh.
another, my lord, lecturer.
Then on top you say applicant takes steps for service of notice on 7, 8 and 10.
10.
Huh? And
They
then
will have to be-
additionally, dusty service 7, 8 and 10. Okay,
Lord, I propose 18th. 18th
okay, it would.
of June.
তোমার বলো কারণে